Good afternoon. Welcome to the People's Law School, presented by the Black Women Lawyers Association. This is our virtual edition. I'm attorney Chandrika Simmons, also known as Law Chick. I have with me attorney Julie Gaffney. Julie, can you introduce yourself?
Sure. Thanks, Chandrika. Good afternoon, everyone. My name is Julie Gaffney. I'm an attorney. I specialize in labor and employment law in the state of Michigan. I do work statewide. My office is centrally located in Saginaw County, and I've been practicing in that area for 25 years now. And I appreciate the invite from Black Women Lawyers Association to participate in the People's Law School. I'm looking forward to it. Thanks, Chandrika.
Thank you, Julie. I'm currently the treasurer of the Black Women Lawyers Association, the immediate past president. I'm also a lawyer in private practice, and I practice labor and employment law as well. And I do family law and probate law and contractual law. I can be reached at 248-732-7559 for all your legal needs. Today, we're going to be addressing the topics of labor and employment law. Because of what's happening now with the pandemic and COVID-19, people have a lot of questions regarding their employment as it relates to unemployment, being laid off, being discriminated against on the job, being fired during this time. So we're here to answer those questions. So if you would like for us to answer a question for you, please just type your question in the comment and we'll post it and try to address the question to our best ability. So the first question we have right now, Julie, let me put that up for us. So can you tell us a little bit about what rights people have during the COVID-19 pandemic? Julie?
Thank you, Chandrika. And obviously I'm going to address this, what employee rights we have during the COVID-19 pandemic. As you know, the pandemic has changed working life. We're no longer just employees. We're furloughed or we're laid off or we're working remotely. We're essential workers or we're critical infrastructure workers. We're no longer just employees. And so the federal and state legislators have been working very hard to come up with laws to address all of the challenges that there are with COVID-19 and the shelter in and the stay home and all of the unemployment that's occurred as a result of those orders. And effective April 1st, there were some federal laws that were put into place. The first one was the Family First Coronavirus Response Act, and that includes emergency paid sick leave. The federal government, under the coronavirus relief and economic relief laws, also expanded unemployment. We're going to talk a little bit about that. And the Family Medical and Leave Act, which is a federal law, expanded to provide more rights in the workplace during this pandemic. Under state law, we have all of these executive orders that have been entered, and many of them relate to employment situations. One of them relates to unemployment expansion in Michigan. One of them relates to not being subject to discharge, discipline, or other adverse action because of having to stay home due to COVID-19, because you're suffering from symptoms, been diagnosed, or because you've come into close contact with somebody who does have COVID-19. And there's protection for employees who stay home as a result of that. The Michigan law already has in place a paid medical leave for employers with over 50 employees that also protect people during this time. So let's talk about those federal laws that we just talked about briefly. And the one is the Federal Emergency Paid Sick Leave Act. And what's important to know about this and the expanded Family and Medical Leave Act, as you know, Chandrika, unfortunately, those laws specifically exempt and allow for exclusion healthcare providers and first responders. So I'm going to talk about what rights you have for paid sick leave and for expanded Family and Medical Leave Act. But if you're a healthcare provider or a first responder, these rights don't apply to you. And frankly, the healthcare provider definition is very broad and essentially includes anybody who works at a hospital, a doctor's office, a nursing home, any employee, frankly. I think it arguably would even include maintenance at the healthcare provider because of how broad it is. It just basically says any employee. So unfortunately, those employees are not covered. What the Federal Emergency Paid Leave Act does is if you were working as of April 1st, and one of the ways in which to get paid applied, and we're going to go over those ways in a moment, you would get up to 80 hours of pay. So essentially 2 weeks of pay by your employer. And it applies to any employer with 500 employees or less. So you can be an employer with 10 employees and it applies to you. Now, there is a potential exclusion for small businesses under 50, but you have to show if you're a small business under 50 that it would be too much of a burden to follow this law. So what are the reasons that you can get up to 2 weeks pay under the Federal Emergency Paid Sick Leave Act? The reasons are if you're subject to government quarantine or isolation order related to COVID-19. Now, what's important to know is that didn't apply. So we had the March 24th was the first stay-home order issued in Michigan. And so if you were laid off as a result of that stay-home order, and then April 1st rolls around, you aren't eligible for this paid sick leave because you were laid off. You weren't employed as of April 1st. So let's say you were an essential employee. Let's say you were, working at a plant that, manufactures masks, for instance, and you were still working as of April 1st. If you had symptoms relating to COVID-19 and you were awaiting a test result, you could get paid up to 80 hours. So if your healthcare provider has advised self-quarantine due to concerns related to COVID-19, you're experiencing symptoms, for instance, you could get this 80 hours pay. And it's a maximum of $511 a day. And again, it's for about 2 weeks. And if you have PTO, for instance, or sick pay, you can choose if you're an employee to use that, but you don't have to. Your employer must pay you the 2 weeks. Now, there's other ways to get the sick pay, but at a reduced rate of 2/3 or up to $200 a day for up to 80 hours. And that includes caring for an individual who is self-quarantined or someone diagnosed with COVID. So if you're the caregiver, or if you're caring for your child because your child can't go to school because the school's been closed due to COVID-19, or because your child care is unavailable due to COVID-19. You may be eligible for this 2/3 pay for up to 2 weeks. Now, what's interesting is if this latter reason, if you're unable to work due to a child not being able to go to school, a school-age child whose school is closed and you have to care for that child, under the Expanded Family and Medical Leave Act, you're actually entitled to 10 additional weeks at 2/3 pay, up to $200 a day, and your employer has to pay that. So this doesn't apply, again, if you're laid off due to COVID-19, that's unemployment. But if you were working at the time that you were unable to work due to COVID-19 or to care for a child that his or her school is closed, then this federal paid sick leave would be applicable. Now, The federal law also expanded, as well as Michigan, expanded unemployment availability for individuals who are off work, unable to work due to COVID-19 reasons. Now, in Michigan, if you become unemployed, you may be eligible for regular unemployment if you're laid off. I mean, that's a typical reason you would be entitled to regular unemployment under Michigan law. If your hours have been reduced at no fault of your own, if you can't work because a medical or public official has directed you to quarantine or self-isolate, or you're caring for somebody who has COVID-19. Those are all reasons you can get unemployment in Michigan. It was expanded under executive order to cover people under those circumstances. Now, you've probably heard of pandemic unemployment assistance. That was part of the CARES Act under federal law, and that allows employees who are not eligible for unemployment under Michigan law, for instance, to get unemployment if they're unable to work due to COVID-19. And it allows individuals who are self-employed, who are low-wage earners, who are gig workers. If you work for Uber or DoorDash, those are individuals called gig workers. Or if you have exhausted your regular unemployment and you're unable to work due to COVID-19, then you can file for unemployment through the regular unemployment site, through BWLAM, it's called in Michigan, and apply for pandemic unemployment assistance. Now, that pandemic unemployment assistance extended unemployment benefits for 39 weeks. It typically was 20 weeks before this COVID-19 became a real issue. And the other thing you're hearing about is the pandemic unemployment compensation, which is under the CARES Act and allows for $600 additional. And in Michigan, if you're entitled to $1 of unemployment prior to July 31st, 2020, even if you're getting the unemployment under Michigan law versus the pandemic unemployment assistance, you still get the $600 as well. So everybody gets the $600 if they're collecting unemployment during this time period, and it's applicable through July 31st, and it gives you $600 extra in addition to however much you're getting for unemployment under Michigan, or however much you're getting for unemployment under the pandemic unemployment assistance, which at minimum is $160 and it goes up to $318. So Chandrika, I can keep talking about this stuff, or do you have another question?
No, you're good, Julie. You covered pretty much everything. What people should know, though, just pivoting from the applying for unemployment, because this is the situation that our Michigan unemployment system has never experienced ever. It is quite overwhelmed with applications for unemployment. So therefore, people need to actually be patient with the system. I think that's key when you're applying. Don't get discouraged with applying, because as Julie stated, you're still entitled to those things based on this pandemic affecting a lot of us, including a lot of independent contractors who traditionally do not qualify for unemployment. So we encourage you to not be discouraged by the process. Do follow the directions that are given to you inside of when you are in BWLAM, which is the Michigan unemployment system. You need to follow the directions. I encourage people to click on all the tabs so that you'll know what those tabs are, what is hidden under those tabs. So some of those tabs contain your letters of determination, telling you how they have determined whether or not you qualify. Some of those tabs state that you failed to certify properly, and you have to actually certify every week for pretty much to show that you've been actively working or looking for a job, or that you haven't, but you have to inform unemployment agency every week, and those are called certifications. And if you don't properly fill them out, then they'll be deemed not determined, or you're being eligible for that week of pay. So you actually need to click on all those tabs to make sure that there are no hidden things waiting for you. What I have experienced in helping people navigate the unemployment system is that when you first go into the system, it has what they call a to-do list. You can click that to-do list, and prior to this pandemic, if you click that to-do list and there were things for you to do, they would be listed in the to-do list. What I'm experiencing now is that you can click the to-do list and it has nothing there. But yet, if you go directly into your case, you'll see that you do have things to do. So don't rely on the to-do list tab. You actually need to go into your case and click on all your things, because a lot of you have opted out from getting mail the traditional way, and you went green because they give you a go green option in unemployment. And if you went green, that means they're not going to mail you anything. They're going to put everything inside of your case file. So therefore, you need to actually click on those tabs to see what your worker has actually put in on your case file to tell you what your status is, how much you're going to receive, whether or not you've been denied, whether or not you put in the wrong employer, because some of you work for multiple employers, and some of your employers do not pay into the unemployment system. Therefore, you're not able to collect under that employer. And so therefore you would be rejected. So you need to go in with those. You need to go into the system and make sure that you are within your time frames, because if you haven't been approved, you can file what we call a protest. Okay. And you have a time frame to file that protest, and usually the time frame for filing that protest is inside your determination letter. And if you didn't click to see what your determination letter said, then you don't know what's your deadline for filing your protest to actually tell someone, hey, I either messed this up in the system, I clicked the wrong thing, or this is not my employer. What I meant to say was this. Or for those of us who are independent contractors going through this process for the first time, navigating this for the first time, I would encourage you to not get dismayed with the process yet again and apply. All you can do is be rejected. I know in my office, I'm not sure if you received the same, Julie. In my office, I had a lot of people who were scared to apply for fear they might be brought up on fraud charges. Because as we know, the state of Michigan will bring fraud charges against you for lying to unemployment about employment, and they enforce those judgments against you and will garnish your wages to collect the monies back that they gave you. But during this pandemic, we're in uncharted waters, and if you're not working, you're not working, and if you're not working during the time, most likely it's because of the pandemic. Apply. Right. So I would encourage people to.
Yeah, and that's a good point. That's a good point, Chandrika. What I think almost scares people too is the pandemic unemployment assistance covers you if you're a low wage earner, and you typically wouldn't be eligible for unemployment under Michigan law, and your unemployment benefits are actually greater than what you were making. And so people may be concerned that that's fraudulent. It's not fraudulent. That's what Chandrika said is true. This is uncharted territory, and the federal government has given $2 trillion, and now I think $2.4 trillion more dollars to infuse into for the American people and the corporations, so that people can get back on track and spend money when this pandemic is over and get the economy back and running. So, right? Would you agree, Chandrika?
Totally agree. What I'm experiencing is the same with you, Julie. I have people who, my clients who are traditionally get paid by tips. And they don't make a lot of money getting paid by tips. And now they have the ability to apply for the unemployment because most restaurants are closed, because most restaurants are sit down. And so most restaurants are closed that are not doing the curbside service, that are not doing the deliveries. And so they are applying and getting approved. And the amounts are amounts they deem to be a lot, because that's more than what they usually make in a week. As Julie stated, the base amount is $160 that you're going to get every week. And now with the enhancement for the PUA, the Pandemic Unemployment Assistance, you get that 600 in addition to that. So now you're getting 860, getting 760. And then you can also have your taxes taken. I need to say that to you too. I would encourage you to actually get your taxes taken out of your unemployment. It just saves you a big headache at the end of the year. So when they ask you in your unemployment to take your taxes out to do the withholdings, just click yes, because you don't want those type of problems with the IRS. But as Julie stated, it's not fraud. This money is due to you, and you need to take advantage of it at this time. All right, we got another question in here, Julie. Let me put this one up. Let's see. All right, the question is there something an employee can do if employer insists that he work in unsafe conditions? For instance, going into recently vacated homes to clean them out without the home being sanitized. The home was vacated because the occupant died last week and no one knows what he died from. The employee feels that it is unsafe and he is being threatened with termination. Any thoughts, Julie?
Yeah, this question's coming up a lot. And, you know, there are administrative agencies like MIOSHA, which is the Michigan Occupational Safety Health Administration. Then there's the federal OSHA. And when in those regulations encourage employees who feel unsafe to first go to his or her employer and say, listen, you know, I feel unsafe. I think this violates MIOSHA guidelines and regulations. And I would like you to, you know, I want to get to a place where I feel safe working, and I don't feel safe because of X, Y, and Z. And, you know, and if it doesn't get corrected, the employee can contact OSHA. Now, it's probably not going to be addressed immediately. There's a backlog, and unfortunately, the agency is not going to help the situation that quickly. So you're kind of stuck. And if you're terminated for contacting OSHA, you are protected under the Michigan Whistleblowers Protection Act. So there are protections in Michigan for employees who blow the whistle, but that doesn't necessarily address your immediate concern of being in a safe working environment. I mean, at some point, if it's that unsafe, arguably, under the public policy in Michigan, it would be okay for you to, after you've tried to rectify it, and if it continues to go unrectified, then if you feel you have no other choice but to not work in that environment, to refuse, then that may raise a public policy issue. What do you think, Chandrika?
I agree with you, Julie. My only thing is, because we both have experienced these questions in our office. My only thing is that you have to worry about your health right now. Okay, we can argue about it after the fact, that you can state that you're not going in and argue it after the fact. But if you're not here, I can't help you. So we have to take that, and we've got to apply some type of common sense to situations. And also at the same time, documentation. I operate from the rule of thumb that if it's not written down, it didn't happen. So if you don't have any written correspondence between you and your employer stating that you told them that you're not sure about this entering into this unsafe work environment, and that you don't feel safe doing it, most likely they'll deem you as insubordinate, and you'll have no proof to show that you did anything other than your word. And basically in labor and employment law, your word means basically nothing. If it's not written down, again, it didn't happen. So I'd encourage you, most people nowadays have what we call this smartphone. And I would like for you to actually use it to its full capacity. That means it has text ability, it has email ability, it has fax ability, it has all these things you can download apps to do. So I encourage you to actually use those things to correspond with your employer when things of this nature come up. So if you're having difficulties on the job, just like the employer documents you for everything, all the violations, all the tardies, all the attendance issues, you need to document the employer when you have issues as well. And that would be when you deem a work environment unsafe, when you deem that there are issues that they should address that they're not, or giving them time frames to fix something and they haven't done it. That stuff needs to be in writing, because what happens is you don't write it down and then you come calling me and Julie and I, and then we'll ask you, where's your documentation to show proof of that any of this occurred? And you say, oh no, I told somebody, or I have a coworker who will vouch for me. You hear that a lot, Julie? I have a coworker who will vouch for me. He'll testify and give.
Absolutely. The problem with that, Chandrika, is especially if the coworker is still working there, that coworker is likely not going to vouch for you because he or she is afraid of being terminated, him or herself. So.
Okay, we have a follow-up question, but I think I answered that, and that was, is text acceptable admissible documentation? Yes, a text message is acceptable written documentation of a transaction that actually took place. Yes, it is. All right, we did pretty good on that one, Julia. Great job tag teaming that. We have another question. Let me post this one. It says, my employer has recently reduced my hours to 20 hours per week. As a full-time employer, we were initially receiving hazard pay in addition to disaster no work pay, where we worked 20, but we were getting paid for 40 hours per week. Today, we were informed that those funds have been exhausted and Oakland County can no longer sustain this additional pay. We were informed to file for unemployment insurance for the remainder of 20 hours. Does the additional $600 per week apply for underemployment? Julie?
I believe so.
I believe so as well.
Yeah. My understanding is regardless of the amount you get in unemployment, you're eligible for that additional $600.
Right. I agree as well.
Yeah, one thing I was going to say, and since we got on another unemployment question, is I just wanted to mention to anybody out there who's having issues with unemployment that the unemployment agency actually does have YouTube videos that are very informative. If you go on YouTube and look up Michigan Unemployment Insurance Agency, they have videos on how to file for pandemic unemployment assistance, how to set up a MyWAM account, which is an account you have to set up if you're going to get unemployment, how to claim your weeks of unemployment benefits, how to file a claim, and filing for unemployment benefits. Those are all different videos they have on the Michigan Unemployment Insurance Agency on YouTube. So if you have questions, I'd encourage you to go to YouTube and just type in Michigan Unemployment Insurance Agency, and those videos should come up. And there's a lot of information contained on those videos, and they're actually put out by the unemployment agency. So just thought I'd mention.
I'm glad you did, because it's a great resource, and they actually they do the online screening, so you can follow the click tabs to show where they're going on those videos. It's very informative, and I would encourage people who are subscribing to shows and things on YouTube that don't help their lives to subscribe to things that actually help their lives, and that would be subscribing to the Michigan Unemployment YouTube page, the State of Michigan's YouTube page, our governor's YouTube page. She has one as well. Those are pages that if you subscribe and hit that bell button, once things are out, and such as the governor's executive orders, changes to unemployment, you'll get notification of those things. So you're more well informed than everyone else. All right, we have another question here, Julie. Let's put that one up.
So actually, you just mentioned Michigan executive orders, and there is a Michigan executive order EO 2020-36, which was signed by Governor Whitmer, says you cannot discharge an employee who stays home due to symptoms of COVID-19 or who stays home because he or she has been in contact with someone with COVID-19. And so the answer would be no. Here's the thing, though, Chandrika, and I'm sure you know this, but as to that second reason, if you've come into contact with somebody with COVID-19, that doesn't apply to healthcare, first responders, childcare, or correctional. And presumably the reason that has that carve out is because those individuals are going to come into contact with people with COVID-19. And so they have that carve out. However, the people in those classifications, if they take time off because they are experiencing symptoms or because they have COVID-19, they cannot be fired. They cannot be retaliated against. Unfortunately, the executive order also says it doesn't specifically create a claim, which is problematic. But arguably, by issuing that executive order, it's creating public policy, and there may be other ways to argue that a claim is made. So I believe under the executive order, you are protected. Whether you'll be able to sue or not is still a question mark. I mean, I think certainly it would be against public policy to have that executive order and not let people seek remedial action over it, like suing.
Oh, I totally agree. I have a client that I picked up this week because she is a healthcare worker. She works in a nursing home and she did contract COVID-19. And for those of you who don't know about this virus, that you test active when it's in your nose. I just learned these things this week. You test active for the virus when they do the testing in your nose. However, the virus can run its course, but it'll still be in your bloodstream for up to weeks later. And so therefore, you still testing through your blood samples that you still have the virus, you still can't go back to work. And so I picked up this young lady this week, and her employer retaliated against her because she was unable to return back to work because she's still testing positive for COVID-19. And instead of them being sympathetic to it because she did contract it at their facility, they decided to put her on what they call contingent, meaning that she will be on a list of employees they may call back to work. And so in my view, that's retaliation because of the COVID-19. And so a nice little letter is going out to them today regarding that. However, as Julie stated, the remedy, I'm not sure what I started drafting yesterday. I'm trying to figure out what my remedy is going to be other than citing the executive orders. I tell my clients, potential clients all the time, they come into office, you can sue for anything. The question is, will you win?
Absolutely. I totally agree with you on that. Right.
Right. So, yeah, so you can't be retaliated against. The law protects you from if you have contracted it, if you're a first responder or a healthcare worker. But we all know it's business as usual for some people when it relates to how they treat their employees. And some employees are not being treated with compassion and care during this time, even though this is something that we've never experienced. So if you have issues like that on the job, I encourage you to contact myself. You can reach me on my website, lawchick.com, or also contact Julie as well, and we can flesh out these issues for you and see what direction you may need to go in, and if you have a viable claim. Julie, you want to pivot to some harassment and discrimination wars?
Sure, let's pivot.
Okay, let's go. All right. Okay. Question is, what do I need to do if I am being harassed or discriminated on the job? Julie?
The first thing you need to do is look to any personnel policies, handbooks, or procedures or postings that the employer has as far as protections for discrimination and what the process is that the employer has to have internal complaints. It's important to make internal complaints under the policies if there are policies, so that later the employer doesn't say, well, we provided you notice of our complaint procedure and you did not avail yourself of that. So in order to, and you want to give an opportunity to the employer to remedy it, frankly. I mean, that's the hope, is you want it to get remedied. So that's one of the first things I'd recommend. And legally, under the law, you can't be retaliated against for making a complaint of harassment or discrimination. And so you shouldn't be afraid of retaliation because you are legally protected. The other thing you can do and should do is be documenting these things, like Chandrika said. You don't want to be destroying any potential evidence. You want to maintain that. And you want to do that without any accusation against you that you've taken proprietary or confidential information. So Chandrika and I are encouraging people to keep documentation, to take documentation down, but don't take the employer's confidential or proprietary information. That's important because you don't want to later be accused of stealing anything. But it is important. Your own notes about the harassment and discrimination is your own notes. It's not their proprietary information. So that's the first step I would encourage. If that doesn't remedy the discrimination and or harassment, there are administrative agencies you can turn to. There's a Michigan Department of Civil Rights. There's also the federal administrative agency that investigates civil rights, and that's the Equal Employment Opportunity Commission. You can also seek legal advice. And those are some of the things that you can do. What do you think, Chandrika? What else would you recommend?
I agree with everything you said, Julie. I would just reiterate or double down on keeping contemporaneous notes with you. I found that a lot of my clients who come in with a notebook that shows on this day such and such was present, this happened. Those actually work for me when I'm drafting complaints for discrimination in the workplace. And it's very hard to overcome my fact pattern because, when we file these complaints, we get to the court first. So the judge reads our stuff first. So once it's in your head, it's in there. That's how I view it. And so I've basically told my story, and I've been able to back it up with dates and place people there. And it's hard for an employer to overcome those. And I have experienced employers who have called me and off the record to say, I can't believe that this is actually occurring here. What do you need? Based on just my fact pattern along my pleadings and my facts. So I encourage you to take notes. Just like Julie said, do not take stuff from the job that belongs to the employer, but your notes are your own and you should keep those. And also, most employees correspond with their HR via email nowadays. You need to keep those emails. And if your emails are connected to the employer's email, blind copy your email to yourself, to your personal email, so you'll have a copy of those, because a lot of people get shut out of the system and then they don't have access to their emails, and that doesn't help me at all. So I would encourage anytime you're emailing something back and forth to the employer that you copy your personal email, so you have a record for yourself of what is actually taking place as far as that goes. For those of you who are, because this is Michigan, a lot of you are unionized. So like Julie said, you look to the HR manual, but what I found is I was a union lawyer for many years, and what I found that in contracts that I negotiated over with, some of those older contracts have provisions in it for addressing a harassment and as being part of the grievance process, which I don't agree that they should be part of the grievance process, and I don't believe that they should be in your labor contract, but sometimes they are, because when they're inside the labor contract, it kind of limits your rights. And I don't agree with them being inside of the contract, but you need to look into your collective bargaining agreement and your contract to see if the issues of discrimination or harassment are addressed in those contracts, because a lot of those antiquated articles that are in there, the employer will hold you to. So before you start filing other complaints, they'll show you in your union contract where it says, oh, you had to go through the grievance process or some old antiquated process to address discrimination or harassment in the workplace, and because you didn't do that, you jumped a couple of hurdles ahead of time, and now you got to backtrack and try to do that. But what happens is you become collateral, and a target, and people need to be aware of that. That when you do stick your neck out and put the employer on notice that you're not being treated well on the job, you do make yourself a target. It's just how it is. I can't say that it's something going to change or something different, but people are people, and people bring their issues and biases to the job, and they treat you accordingly. And so, yes, when I get all the time, I'm sure you get it too, Julie. People call and say, the HR is in cahoots with my manager, and I can't. My manager's not doing what they're supposed to do, and I'm telling them you have to go report it to HR, and they're like, well, they're working together, and I'm like, well, that's when I need the documentation to come in that you've done what you're supposed to do, because when we do get cases that a potential case for harassment or discrimination lawsuit, the first factor is, did you put the employer on notice? Mm-hmm. And if you didn't put the employer on notice that there was an issue, we've lost before we even began. Mm-hmm. Because you have to give the employer, as Julie stated, you have to give the employer an opportunity to rectify what it is you're saying is an issue on the job. If you didn't do that, you jumped the gun. And I get a lot of employees who have worked for an employer for many, many years and let so many things slide, and then they just reach their breaking point. And I understand you went 20 years of being treated bad, but in those 20 years, you never said anything. Never documented anything. And with that being said, I sympathize with you, but I can't help you. It doesn't equate to a lawsuit. Do you get those too, Julie?
Oh, absolutely. And I understand the fear. There is a real fear of retaliation, and if you're working, you need the job, but if you want there to be change, if you don't like the harassment and discrimination, you do have to put the employer on notice. And when they don't take that opportunity, and unfortunately, a lot of times that opportunity to change isn't taken, then you definitely have a much better argument, like Chandrika said, to say, I've been discriminated against, I put the employer on notice, and nothing changed.
While we are talking, Julie, because I don't see any questions in queue right now, how do you feel about people who come into your office with expectations of winning $1 million lawsuits for employment discrimination and harassment claims because of stuff they watched and seen on TV? Would you care to elaborate on those?
Well, I mean, I think you mentioned earlier about, you could say anything, but it doesn't make it legal or illegal. Just like damages, just because you want $1 billion or $1 million doesn't mean that that's what the claim is worth, or that's what a jury will award you, or that's what you could ultimately get. So unfortunately, a lot of it is managing the expectations of what the actual amount is you can get. And the other thing is, Chandrika, is that there's huge risks. I mean, in employment cases, unfortunately, employees that are at a disadvantage, and the employer has more advantages under the law. And you're already starting at a disadvantage when you're an employee bringing a claim. So, these cases can be worth a lot because somebody's employment is worth a lot of money. And so that has to be taken into account. But also the risks that exist need to be taken into account too. There's no guarantees, as you know, in a lawsuit, Chandrika. And I think when you're evaluating cases, you have to evaluate the risk as well, and take that into account.
I totally agree. Have you had any cases come into your office lately that are unusual?
Well, we always get unusual cases or unique cases. Every case is unique. I'm not sure of any one specific case that I can point out that I feel slightly uncomfortable with. Not just because I don't necessarily want to talk about an existing case, if in case.
Oh no, I'm not
I
encouraging
don't
you
want
to
to
talk
make a
about it.
client feel uncomfortable.
Over the years,
What about you?
I'm sure you had some interesting cases.
I didn't
We
hear
have
that.
Hold on. Yeah, I'm good. We have another question.
So the question is, how does an employer avoid treating an independent contractor as an employee? And that's a good question. And just because an employer says that an employee is an independent contractor doesn't necessarily make it so. And so legally, there's rights under statutes that protect employees from discrimination, from being retaliated against, giving workers compensation. But if you're an independent contractor, those laws that protect employees don't necessarily protect you as an independent contractor. And so it's to the employer's advantage sometimes to call you an independent contractor as opposed to an employee. But just because your employer labels you as an independent contractor doesn't make it so. The court's going to look at such things as how much control does the employer actually have over the individual called an independent contractor. The more control the employer exerts over that individual, the more likely that person is actually an employee, not an independent contractor. For instance, is the person able to decide his or her schedule? Can the person decide what to do on a day-to-day basis? Is the person highly supervised? If the answers to those are yes, and the employer is exerting a lot of control or telling the person involved, you can't work anywhere else, you have to work just for me, those types of things all suggest that the person is actually an employee. And so if the law is violated, for instance, let's take discrimination for an example. If there's a discrimination claim and the person is an independent contractor, arguably that person typically would not be able to bring a discrimination claim under the civil rights laws. But if the court finds that person is actually an employee, not an independent contractor, then he or she can bring a claim. So, so just because you're called an independent contractor doesn't make it so.
Oh, I totally agree. And I think what we experience a lot is companies avoiding having an employee for tax reasons,
right,
and trying to avoid paying benefits and paying unemployment insurance into the state of Michigan. It's a lot of reasons why an employer would not want to claim a person that's doing every facet of a regular employee as an independent contractor. So there are reasons why they want to do that. I think both work. Do you do work for businesses as well as workers?
Not much, very, very little. I tend to gravitate, and my interest and my specialty is to represent employee rights. And so I don't take on a lot of businesses, and I don't represent businesses in a lawsuit relating to an employment action. Typically, I can't remember any that I've taken in the recent past at all. So typically it's for the employee.
Yeah, I agree. I basically do the same thing. I do represent some businesses, but not against their employees. It's usually the business to draft documents for them and things of that nature, but not so much for suing the employee, because I'm really more of a workers' rights type of lawyer. But because I do contractual drafting, so I know how to put together an employee handbook. So I do a lot of that, things of that nature.
That's a good point. Yeah, I will do that too. And if there's employee issues, I'll assist with those. And frankly, I think it's helpful to employers to have somebody who's more employee right-minded sometimes to look at a scenario. I could tell you this. Recently I did have a harassment case, a sexual harassment case, and the defense attorney, who was a management firm, went in and talked to all the employees afterwards and told all of the employees the plaintiff is always the problem. And so I don't think that was helpful to the employees, because it perpetuates retaliation and perpetuates blaming the victim of the sexual harassment. So in that situation, if they would have had somebody more employee rights minded, he or she would not have said the plaintiff is always the problem.
Right.
So that's a good example of how we can help corporations be more employee friendly, because it can help them stay out of litigation, frankly.
Right. I believe that a lot of employers don't. I guess it's the American way. I wish it was totally different, but a lot of employers don't adopt the philosophy that if they treat their workers better, their workers will be more loyal to them. Because what I found is that if you treat your workers well, they are loyal to you, and they'll do everything to support you in your goal, your end goals. But if you treat them horribly, it does not work in your favor. So I don't, been in this business, we've seen a lot of things, and I don't understand why people come to the job and are hell bent on harassing the workers there. But it happens, and it happens often. And that's how we stay relevant as labor and employment lawyers.
Yeah.
Right. So we're almost at the hour mark for us. Julie, did you want to address anything before we get off?
Just that.
Or reiterate?
I'm sorry, what?
Or reiterate anything we've covered?
Well, what I would just say is during these challenging times with COVID-19, it's important to also remember that in addition to the rights that we talked about at the start of the show, that are new laws that have been passed to address COVID-19, employees still have the rights that existed before COVID-19, such as the rights under the Americans with Disabilities Act, such as the rights under COBRA, things like that. So just because, we're going through this pandemic doesn't mean that your rights are out the window. So there are employee rights, and it's important that those are followed, especially during this time when there's so much uncertainty. So I appreciate everyone who's listened in, and I would say, stay safe and know your rights.
I totally agree. I would encourage you to not be intimidated by the process that is a labor and employment law, that we are here and available to answer your question that you may have on the job. It's better to ask than to sit in silence and in ignorance. And so we would encourage you to reach out to either of us. If you have issues that are on the job, such as harassment, discrimination, and any workplace issue, wrongful terminations, we also do those as well. So if you feel like you've been terminated from your employer wrongfully, both Julie and I handle cases such as that. And so we are here for you and available, but we hope that you take heed and listen to the tidbits that we did give today, such as documentation and the fact, documenting everything on the job, and the fact that during this pandemic, A lot of your rights are still protected, and because of this pandemic, you have some more enhanced rights and some more access to different things that you didn't have access to prior to. I want to thank Julie for being on this panel with me. I appreciate you more than you know. For those of you who may not know, we are the Black Women Lawyers Association. I am the media past president. Julie is the media. She's a past president of the Women Lawyers Association of Michigan, and she's also a member of our organization, the Black Women Lawyers Association. And they're both two great associations out here advocating for women in the legal field. And we encourage you again to seek one of us if you have any issues on the job. Thank you so much, Julie, for attending the People's Law School and being one of my panelists. I greatly appreciate you.
Thank you. I appreciate you. Have a great day.
You too.